This is a reply to Anna, a representative from British Gas. This is what she writes. Hi Andy, I have been sitting with my manager and I have gone through your account to check all the details before we deadlock your complaint. Your complaint is about the fact that we have called for your final balance via direct debit. This is our reply to that. If it were £100, it would probably have been acceptable, but not the amount you attempted to appropriate yourselves with. This was a raid. You are not entitled to take any disproportionate amount of money without the customer's explicit consent. This is commonly recognized out of proportion, clearly beyond any counter-argumentation and commonly accepted in the UK. And they carry on, British Gas carries on saying, you have advised that you didn't know about this bill because you haven't received any bills. This is our reply to that. We did not know about this PDF document you refer to as a bill. For more information, read the previous correspondence again, please. This is what they say also. British Gas says, I have checked your online account and I have attached your final bill for your reference. This is our reply. It is good that you are able to check these matters online. This is what they say. You will see on this bill that we advise that we will be calling for the balance within 14 days of the bill being produced. This is what we reply. This is the first time we see what you refer as balance. We continue. I have stated clearly in the previous correspondence that the sort of amount is disproportionate and clearly unreasonable. Are you able to read the emails? After seeing what you refer to as a final bill, we asked ourselves, how about producing a final bill for £300 million on exactly the same basis? Your so-called bill has clearly no standing whatsoever. We continue. What is more surprising is that you even produced it. We can easily prove the document you just submitted is not valid and cannot be reasonable. This will be done in court if necessary. We do not do it here as you seem to have lost any common sense, respect of the law, unable to use reasoning, act fairly, and to even understand the previous correspondence we sent you. Then the representative of British Gas carries on in the following way. I have also called G4S to query why there were so many estimated readings. They have advised that between 2010 and 2012 they attempted to read the meter several times but could not gain access. They have also advised that they have tried several times in the last 12 months to get someone out to read the meter. This accounts for the high balance as well as the fact only small payments were made over the time you've been with us. The previous statement I've just read is incredible because this is how we reply to that. All the statements above are demonstrably not true. We can prove this in court. We are surprised and outraged that in order to justify your position, you put in writing false and misleading information. And the beauty of this is that we can even demonstrate it. Then the representative of British Gas carries on this way. Your bills were sent to you online, which you have advised is your preferred method of communication. This is our reply. You are just stating that. This I do not recall. And this is how they carry on. we have not acted inappropriately by sending your bills online and shouldn't be blamed for you not accessing your account. This is our reply. I have no access to this online account you are mentioning. You do have acted unreasonably. We can prove you even lied a number of times, and you, British Gas plc, alone seem to pretend not to realise your behaviour is unreasonable. See our previous correspondence for your reference. Then the representative of British Gas carries on in the email in this way. I understand that you are frustrated and angry that we tried to take the final balance via direct debit. This is our reply to that. Once again, you had not tried to appropriate yourselves with £100, but over £3,000 without my explicit consent and without getting in touch with me to ask for explicit consent. Just as an example, to put things into perspective, if you were within your right to act in this manner, energy companies would be able to wipe out bank accounts without the need to ask for permission, explicit permission. This does not normally happen in the UK and any civilized country. This is because this sort of conduct is commonly recognized as unacceptable and inadmissible in any civil society. In the UK, only HMRC has been granted similar powers which you pretend you are entitled to under very special circumstances and still with great controversy. Now, what we're talking about here is the fact that last year in 2014, HMRC was given the right to raid people's bank accounts if they think you owe them money. But in the case of HMRC, the law apparently says that they can only do it if they meet face to face with you first, and then you have 30 days to appeal to that decision made by the HMRC. And clearly, if even HMRC does not have the right to take disproportionate money from your accounts without even meeting you face to face, obviously no energy company is able to do something similar at all, and let alone what British Gas has done previously. We carry on this way. You, British Gas plc, clearly do not have this sort of right or power, and this cannot be legally granted, even contractually. Once again, please refer to previous correspondence. Maybe you will understand this time. Then the representative of British Gas carries on this way in the email. And I have gone through your email and, as advised, take on board all your points. However, I think that the monetary amount that you are asking for is unreasonable, hence why I am having to deadlock this complaint. To that, we reply in this way. The amount we are requesting is more than reasonable, far more reasonable than the amount you have attempted to raid our accounts of. And we can prove this in the court of law if required, and of course, publicly. British Gas carries on this way in the email. I still have to get the letter authorised and checked, but I thought it best to email you to keep you updated. This is our reply. This email is considered as an official reply from British Gas plc because to us or any other party, you are the legal company representative despite of your position or ranking within your organization. This email and any information you send to us will be treated as official. Now, it is quite interesting because I'm reading this response on the 22nd, on a Saturday, 22nd of August. They gave us the deadline of the 21st of August, and what happened yesterday, we got another request for payment for that £3,000 odd from a debt collection agency. So basically, although she is saying that this is not official because she's got to check it with her manager, we obviously see that as far as they're concerned is official, because on the same day, on the 21st of August, they sent this request for payment. Then British Gas carries on this way. Please let me know if there are any other points you would like to bring up so that I can refer to them in my letter. Our response is, please keep reading. Then British Gas carries on this way. You advised on the last email that you want £6,670 as resolution to the complaint. Can you advise that this is still the case? This is our response. The amount due to ourselves is £6,670. An extra charge of £600 applies to the production of this response and further legal work on this matter. We are not adding this amount for now, however, this will be added in the future should British Gas maintain their current unreasonable position. Then British Gas carries on this way. I would also like to advise you that the links you sent in the last email didn't work. The only link that I could access that worked was in reference to Sainsbury's Energy in-store mis-selling back in 2013. Now, those links were also in the video that we sent over to them in the description, but just for the sake of it, we're just going to put them again in the description below, but also we sent those links once again, just to make sure that they're able to find them. Then British Gas carries on this way. I hope to hear from you soon. Please get in contact with me by the 21st of August to confirm the compensation amount and that you have received the bill. If I don't hear from you by the 21st of August 2015, I will assume you're happy for me to close the complaint. This is our reply. By this date, we have not received the check, so please make it payable to us. Just as a further note here, we replied quickly on the 21st of August saying that we still need a bit of time to reply to them. Today is the 22nd. And on the 21st of August, we got another letter from, another email this time, from one of their collection agencies saying that they have to pay immediately. But anyway, this is quite interesting. Please carry on watching this video. Then their email finishes this way. If you'd like information about our complaints handling procedure, you can view a copy by either going online at an address or by getting in touch with one of our advisors, which will arrange to send you a copy free of charge. Anna Prince, Customer Relations, British Gas, telephone number, and so on. So we had replied point by point to the letter that British Gas has sent us, but we wanted to add further remarks here just to conclude our email back to them, and this is how it goes. In addition to all the above and previous correspondence, British Gas PLC may have acted in clear breach of and in violation of Unfair Trading Regulation Act 2008. In particular, paragraph 3, part 3.A and B, also part 4, in particular, points A and B. in this latest document, you also provided evidence of breach of paragraph 5.1 and 2, of which A and B. Also paragraph C.1, of which A, B, C and D. Also paragraph 7.2, of which CE made both by British Gas plc and the debt collectors appointed by British Gas plc. Now, you can see all these links to the relevant legislation in the website and also in the description below. Then we carry on. We remind that any trader, including PLC, found in breach of any points of the above legislation is also subject to public or private prosecution, and any terms and conditions or contracts are void by default and by legislation. If required, we are in the position to prove these breaches of this UK legislation, both publicly and in the courts of law, if required, of course. Dear British Gas plc, the fact that some of these practices are sometimes routine in their dealings with your customers, as we have seen in previous cases, does not mean that those activities are legitimate, lawful or sensible. Then we carry on this way. Please note that the only jurisdiction which has power in the UK are the courts of law. If despite all the information we have provided, you still wish to claim any payment from ourselves, you must refer to the UK courts of law. If you do not initiate proceedings before the end of September 2015, we consider the matter closed and no further payment will be made to your company. To summarise, the only authority which can take action on this or any dispute in the UK are the UK courts of law and no other. In the UK, the courts of law are the only authority who have the legal power to validate the legitimacy or request for payments and grant such orders. No other private company or body has such powers. This is the last time we take our time to discuss this matter, since your standing is not only demonstrably illegal, as we're able to prove if needed, of course, but also your requests are based on manipulations, omissions and untrue statements. Any subsequent correspondence we will have on this matter with you, your appointed agencies or bodies, will be chargeable and made public. We will charge as follows: £30 per correspondence generated, £250 per hour for legal work charges, £150 per reply to any debt collection agency you appoint. Any total sums may be recovered through court proceedings if required. The proceedings may also involve the debt collector companies, and they may be held liable jointly with British Gas plc if required. After all, they are made aware of this. We are surprised we had to come to this, and despite it, we would still rather resolve the issue immediately without recourse to further actions. We would consider the matter closed if you kindly acknowledge in writing your withdrawal from any further payments claims. If you opt for this reasonable course of action, we may not decide to pursue you for the payments of the sums rightly due to ourselves. We encourage British Gas plc to reconsider their standing and correct their position amicably and immediately without recourse to further actions. British Gas have the option and are welcome and encouraged to contacting us over the phone to look for a solution instead of incurring in further charges. Alternatively, you British Gas plc shall take legal action before the 30th of September 2015. This allows you more than 30 days to assess your legal standing. If you would like to opt for court proceedings, we kindly ask you to also notify us of such an intention via email. Past the 30th of September 2015, without any legal action, we will consider you acknowledge your claims unfounded, and any subsequent action from your part or affiliated companies will be considered harassment, of which you and the affiliated companies may be held accountable for, commonly referred to as debt collectors. Therefore, once again, we encourage you to please get in touch with us over the phone and settle this matter amicably. Otherwise, please initiate court proceedings within the 30th of September 2015. Kind regards, Andreas Russo.